up and running a startup is not an easy process. There are many important aspects to consider, especially the legal aspects. Legal considerations are as important as your idea when it comes to running your business. Underestimating their importance could cost you your business. A way to ensure legal protection is to have well-prepared business agreements. In this video, we'll be talking about 5 of the most common mistakes found in every startup contract. The most common mistakes new startup entrepreneurs make is not having a contract at all. You should know that, from a business perspective, promises are useless because they are not enforceable per se. Committing to your company means making sure that your business partners do the same. Under a clear contract, the obligations of each party are plainly explained. If a partner, co-founder, freelancer, or employee decides to leave, there should be legal consequences. All business agreements must be formalized and written. This is particularly true when friends and family are involved. Having an agreement in place is only the first step. The second most common mistake is not clearly defining what constitutes breach of contract. Your contract should include terms and conditions and define each party's obligations towards the company and what happens in case they were not honored. Mistake number 3 is not thinking about an appropriate dispute resolution process. As a startup founder, the last thing you want is to waste your time or money on long, expensive lawsuits. Alternative dispute resolution methods such as mediation or arbitration are good alternatives to traditional court process. Mediation is a voluntary process under which parties can choose to negotiate in good faith to find an effective solution for this dispute. Arbitration is when you hire an individual to act as a judge, hear your arguments, and give you a final binding decision. Neither is perfect, but they are both more agile and faster than traditional litigation. Mistake number 4 is not making a contract assignable. Most business contracts include an assignability clause according to which parties cannot assign their duties to a third party without a notice and consent. Companies hire people to perform certain obligations based on their particular qualifications. However, startups are founded with an exit strategy as part of their contractual considerations. Therefore, if an acquisition is a primary goal, it is essential to include an assignability clause in every contract that states that the agreement can be assigned to another company in the event of a merge, sale, or any other purchase. The final most common mistake startups make is not protecting their intellectual property, or what is commonly referred to as IP. The way to execute efficient IP protection is to have a standard IP assignment agreement under which you assign the ownership of your startup's IP exclusively to the startup. This agreement must be executive between the company and its founders, investors, employees, and service providers. Imagine what would happen if one of the founders decided to walk away and refused to assign the work they had done for the company. You want to make sure to have the right IP protection for your business by including the proper legal language in your agreements. The right legal partner can help you avoid all of these mistakes. Make sure to visit Lexium.com to learn more about this. Legally yours, Farah.